Welcome to my YouTube video on handling service of process, specifically serving summons in civil proceedings. I'm Sam from Wilshire Process Server, and I'll be your guide through this essential legal process. Please remember that I am not a lawyer and you should always consult a lawyer before hiring a process server. This is a guide based on publicly available information which I am merely consolidating for you here. Step 1. Determine whether you need a summons. Let's start with the basics. What exactly is a summons, and why do you need one? Well, a summons is a crucial legal document that courts use to compel compliance with their demands. It's a way of letting the defendant know that they are being sued and that they have a limited time to respond. A summons gives notice. A summons serves as written notice to the defendant in an action, informing them of several important things. A. They are being sued, which means a complaint has been filed against them. B. They have a limited time to file a written response to the complaint, which is typically 30 days but can vary depending on the type of case. C. There are consequences if they fail to respond, such as the plaintiff obtaining a default judgment. Why you need a summons. So, why is it necessary to serve a summons on the defendant? Well, there are a few reasons. A. It ensures that the defendant receives fair notice and the opportunity to respond to the legal action. B. It fulfills statutory requirements for the proper service of summons, which can be found in various sections of the California Code of Civil Procedure. C. Most importantly, it establishes the court's jurisdiction over the defendant, a crucial legal concept. When you need a summons. You'll typically need to serve a summons when you serve a defendant with a complaint or cross-complaint. In other words, the civil action officially begins when you file the complaint, but the defendant can't be compelled to respond until they've been served with a summons in the complaint. When you do not need a summons. There are situations where you don't need to serve a summons along with the complaint. This happens when the opposing party has already made a general appearance in the case. What does that mean? General appearance defined. A general appearance is made by the opposing party when they A. File an answer, a demurrer, or a motion to strike. B. File a notice of motion to transfer. C. Give written notice of appearance. D. Serve a notice of deposition or a demand for production of documents. What is not a general appearance? On the flip side, there are actions that do not constitute a general appearance, including A. Moving to quash service of summons for lack of personal jurisdiction. B. Moving to dismiss for lack of subject matter jurisdiction. C. Moving to stay or dismiss for an inconvenient forum. D. Moving to dismiss for delay in prosecution under certain conditions. E. Requesting an extension of time to plead. F. Appearing at a hearing for ex parte relief. If the opposing party has not made a general appearance, then serving a summons is necessary. Final thoughts. One important thing to note is that you must serve the summons and complaint within 60 days of filing the complaint, according to the California Rules of Court. Local rules may have additional requirements, so it's essential to stay informed about those as well. That concludes our overview of handling service of process in serving summons in civil proceedings. If you need more information, be sure to check the relevant sections of the California Code of Civil Procedure and resources like California Civil Procedure before trial. Call or text me if you need service in the greater Los Angeles area. My number is in the description of this video. Thanks for watching, and be sure to subscribe for more informative legal content.